Yes, Mr. Clark.
Thank you. I turn now to the last two appeals.
Yes.
Those generically of scat transport being themselves in both the two appeals and their drivers, rather Kaczynski in the first two. I propose to deal with the two appeals in the way that His Honour Judge Godsmark, Queen's Counsel, did. That is, take them together in determining the overall principles of the thing, and then simply looking at each individual one towards the end. And I can do so quite shortly with your permission.
Certainly.
They were heard both together by the learned judge in August 2021. The facts are very straightforward and again are not in dispute. In the Scat and Kaczynski case, on the 11th of July of last year, a vehicle driven by Mr. Kaczynski arrived at Dunkirk, and the lady understands why I emphasise that in relation to previous discussions, if you like. 7 clandestine entrants, the seal and tilt cords were in place on the vehicle. The tilt cords being, of course, that security cord that we've discussed that goes all the way around the vehicle.
What is the tilt itself, separately?
In the old days, a tilt trailer was a soft-sided trailer that, to some extent, could be tipped. They no longer exist. I'm horrified by the fact that I know this. But these days, soft-sided trailers, that's what they call curtain-sided trailers, are readily accessible to those who want to get in them by climbing underneath and behind the curtain and then over the shallow wooden board and into the trailer. The object of the tilt cords is you will have seen that the curtain is held in place by vertical straps all the way down. The tilt cord is a steel security cord which goes through a small hole in each of the strap handles so that they can't be opened. The idea being it's pulled taut at the back of the truck and then sealed together with some sort of padlock or other locking device, and then a seal is applied so that you can identify if the seal is broken that the tilt cord has been interfered with.
Yeah, well, I know about a tilt cord, but I wasn't sure what a tilt is on its own. Is it a soft-sided trailer?
It was a long time ago, and it's become a generic word for the cord itself. I don't believe tilt trailers exist anymore.
But in one of the cases, there's just a reference to the tilt. I think it's this one.
I think it might be the reference to the tilt cord.
It is.
This was certainly not that type of trailer. This was a soft-sided or curtain-sided trailer.
If I've got nothing else to do, I'll do a word search. Which reminds me, I don't think we've got electronic copies of the bundles. If anybody's got...
Yes, we have.
Yes, we have. Yep.
Well, I'm spot up to date in that case.
So, the tilt cord, unlike in the previous case, had been properly applied.
Well, in this one, this is the only one where it's not known how they got in.
Yes, so forgive me, that was on the first of the two bills. So they were the bare facts. On the second incident, 29th of July of last year, and fairly soon after the first one, again, seal and tilt cords in place, and there was a hole cut in the roof. The driver had a completed checklist. The learned judge undertook his task in the way one would have expected. He looked first of all at whether or not there was an effective system in place. And determining that issue, he made a number of findings. And forgive me for reading out the passages because I rely quite heavily on the findings, particularly when contrasting them with his ultimate solution to the issue. Paragraph 9 of his judgment, he says this: I've been taken to, forgive me, it appears in my skeleton argument at page 29. I've been taken to the extensive systems that they have in operation. Their drivers are trained extensively in separate training schemes for new drivers and for more experienced drivers. Drivers on haulage trips are supplied with the security devices. They're supplied with seals and cords. They are trained in the use of them. They are given written instructions which they carry with them in the cab. They are provided with a checklist which sets out effectively by way of a table what checks have been carried out upon the vehicle, when and where. Those checks include lines for checking inside the trailer, checking the tilt and the roof for damage, checking the external compartments, checking below the vehicle, tilt cords tied in place, seal in place and checked, and where an appropriate, padlock in place and checked. I pause there because your lordships and ladyship will readily appreciate that we are heading towards my scenario of an operator, a haulier, who has done everything that might be reasonably expected of them, and the learned judge has found that to be the position. And indeed, he goes on later in his decision to comment that it is, he says at paragraph 17, a more impressive system than most I see. But at his paragraph 10, he goes on to talk about the presence of a telematic system, which is discussed earlier, and the cross-referencing of the checks that are carried out. The checklist is scanned back to base, etc. Can I just make this point to contrast this with one of the other cases? The checklist that His Honour describes as if set out effectively by the table what checks have been carried out upon the vehicle when and where, is this document. Forgive me for putting it in this terms, the tick box document. So here we have one judge describing this as a tick box document and another commending it in the terms that His Honour Judge Godsmark does. He then went on at paragraph 17, having commended the system, to say this: it is nonetheless criticised by the Secretary of State. It's criticised because it said there is quite literally a hole in the system. And that hole relates to the checking of the inside of the vehicle. If the customer seals the trailer, how does one check inside? Because inside is where the clandestine entrance will be. One can rely to some extent upon seals and tilt cords, but they are not wholly effective. And then at paragraph 18, the Code of Practice makes reference to the checks to the inside of vehicles. Section 1.2 deals with measures which must be taken immediately prior to the vehicle boarding its means of arrival in the United Kingdom. A requirement of, quote, checking inside the vehicle. 20. I accept the system is not one which meets the requirements for accreditation, or at least not quite, and the deficiency lies in particular the ability to check inside a vehicle, particularly one which is bearing a customer seal.
Can you hold on to it?
Forgive me?
Just hold on to it. Ability to check inside a vehicle. Okay. What's the accreditation scheme say about it?
I'm going to produce it. I'm going to ask for permission to rely on it later on. I don't yet have it. Have you got it? Can I please have permission to rely on it?
Yes.
Yes, certainly.
Thank you. No objection.
No objection. It's referred to in the respondent's evidence.
Exactly.
This is the government website, and I can arrange to have this emailed to your lordship clerks in due course, if I can get the registration up there. In terms, it says this: eligibility. The scheme is open to road haulage companies of any size or nationality operating between continental Europe and the United Kingdom. A company must be able to show that it, A, has an effective system for preventing clandestine entrance, and that then refers to the Code of Practice. This is described in the Prevention of Entrance Code of Practice. Well, we've already touched upon whether or not that's prescriptive, or whether or not it is right for the border force to wholly rely upon that, but that's a different argument. And then B, to take reasonable measures to make sure that the system works, e.g. training and monitoring of drivers. That seems to me, with respect, to be a separating out of B and C. The scheme is voluntary. Companies who don't apply to join the scheme won't be disadvantaged and will still be able to avoid fines. I object to the use of the word fine, but there we are. It's a civil penalty, by operating an effective system. There then sets out how you must apply for the scheme, and it goes on to say, and you will see it about what we look at, what we don't look at, etc. That tells you that if you don't comply, they'll suggest how you might in the future. Then it says, if clandestine entrants are discovered in your vehicle, this is paragraph 5, and this thing only runs to 5 paragraphs. We need to request evidence from your driver. The scheme doesn't prevent us from fining drivers if they haven't operated your scheme properly. If you employ the driver, your company must pay the fine imposed upon the driver. As a matter of law, that's wrong.
They're joint several.
It's joint and several. So if the driver pays, forgive me, it's wrong in law. This is the government website. This is one of the issues that we find ourselves up against when dealing with, for instance, the codes of practice. But secondly, the proposition that the government the Secretary of State advances, that the scheme does not prevent us from fining drivers, but not penalising the hauliers who are members of the accreditation scheme, goes right to the
But does it say that in terms about the hauliers?
It says this. I'll read it verbatim.
Please.
5. If clandestine entrants are discovered in your vehicle, that's the heading.
Yep.
We may need to request evidence from your driver. The scheme does not prevent us from fining drivers if they haven't operated your system properly. If you employ the driver, your company must pay the fine imposed upon the driver.
But that's on the basis that if you are accredited,
yes,
you're not going to be fined.
Yes.
Must be. Doesn't say so.
What they're saying is, even if you're accredited, we may fine your driver for failing to operate the system properly.
Yes, and that's the distinction that I was so concerned with to raise.
I think your junior's found another relevant passage. Thank you.
Forgive me, yes. I'm glad she's here. Paragraph 1. I ought to read it in its entirety, it's not long. Under the civil penalty legislation, road haulage companies may have to pay fines if they carry clandestine entrants to the United Kingdom in their vehicles. A clandestine entrant is a person who hides in a vehicle as it enters the United Kingdom with the aim of avoiding immigration controls. It's all rather loose, but there it is. Vehicle owners, hirers and drivers can be fined up to £2,000 for each clandestine entrant they carry. The civil penalty accreditation scheme was set up to reduce the risk of receiving fines by ensuring that companies have effective systems to reduce clandestine entrants. If you're a member of the scheme, and clandestine entrants are discovered in your vehicles in the plural for some reason, your company won't be fined as owner or hirer of the vehicle as long as you're operating in accordance with the scheme. Full stop. Could I give you the web page address? Would that assist?
I've got it.
My lord's got it. Thank you.
Just give me a second. I've just emailed it to you.
Yeah, that is right. That goes to the very heart of my argument, I submit, that I raised earlier about whether or not, about dealing with each responsible person separately. And clearly, the import of that accreditation scheme is to deal with each responsible person separately, because what they are saying in plain terms is that if you have an effective system of prevention in place, and we've approved it, regardless of the conduct of your driver, who will still receive a penalty, you will not. And that, in my submission, is not the exercise of a discretion. It is a statement of policy, notwithstanding that may or may not be a public policy argument in any event. But if it is the policy of the Secretary of State to not impose penalties, not to say I might not impose, which is the exercise of discretion, but to actually actively publicise that if you meet the standard, we will not impose a penalty on you regardless of the action of your driver, then in my submission, the argument that goes at the very least, the exercise of discretion in respect of a company who, like this one here, under the findings of this judge, has everything in place but for the efficient driver, must be in favour, I would submit. And again, must is not a word one should use in the exercise of discretion, but one would seriously expect a judge to exercise the discretion in favour of a company that meets that
So
test,
really
because that's exactly what the Secretary of State is doing.
So what the heart of your submission therefore is that if you can satisfy B, you've got an effective system, whether by way of accreditation and therefore government approval, or by finding of the court at an appeal of a rehearing, that you may fail to establish your defence because there's been operator failure. However, whether you call it policy or proper exercise of discretion, the haulier should not receive a penalty, but only the driver.
Milady has it far better than I have put it, but yes,
That's your case.
That is my case.
And that applies to HHJ Fine,
Yes.
which was the insecure tilt. It applies to the failure to produce the checklist, other Honour Judge Co. And it applies to the 11th of July checklist not filled in. Query slightly different, the checking the inside.
Well,
You can deal with that separately,
yes,
but for you say
yes.
on a straightforward analysis, all of those other appeals fall within that category.
Yeah. And I argue, forgive for want of repetition, but I argue that appears to be, on the back of that document, the Secretary of State's position.
Of course, that's not the basis of your appeal.
No, it's not. But I would venture that I'm entitled to pray and aid that which is published, because my general submission is that this whole scheme is ambiguous and unclear, and that is one of the grounds of my appeal. And one of the reasons why it is unclear and ambiguous is, as my Lord has pointed out, in Annex A of the penalty letter it says one thing, in the scheme it says another, and here we are on the published documentation it says another again.
But all of this arises if Judge Godsmark was right to say that your system was ineffective.
Oh, it's why he says it's ineffective.
But if he was right to say that the system as such was not effective, then your argument about exercising discretion to have no penalty at all, or not to impose a penalty, runs into difficulties. Your argument is strongest if a judge says, well, the system is fine, but they're in breach simply because of the operator.
Yes.
Right. Well, I don't at the moment understand how we can decide the Godsmark case, because just looking at the accreditation scheme application form, which is a link from the page you were, it says, as one of the questions, it has lots of stuff about vehicle security, what's provided and so on, vehicle checking. And vehicle checking, what procedures are in place for checking that vehicles do not contain unauthorised persons at the time of loading? Who makes those checks? Next question, what instructions are given to drivers regarding checks to be made en route? Please give details regarding the timing of checks and how they're to be carried out, or attach any written instructions. Now, if you go back to the Prevention Code of Practice, 1.1.1 on page 31 of the bundle, of the authorities bundle, says before final loading takes place, all existing, no, we're not worried about 1.1, that's cuts and tears. 1.1.2, if present at the time of final loading, the owner, hirer or driver of the vehicle must check it to ensure that no persons have gained entry and are concealed within. It must then be locked, sealed or otherwise made secure. If not present at the time of final loading, the owner, hirer or driver must, where possible, ensure that such checks are conducted, so on and so forth. Where the final loading has been completed, the load space must be secured immediately by lock, seal or other security device. And then if you go over the page 1.1.8, where a sealed container except a container sealed by customs, is loaded onto a vehicle, the owner, hire or driver must, where possible, check to ensure that it does not contain unauthorised persons. It must then be resealed and so on and so forth. And you discussed with my Lord, particularly Lord Justice Warby this morning, the meaning to be attributed to 1.2.5, which is the final check. Well, at the moment, although it would have had to be sent to the border force if you were applying for accreditation, we haven't seen your system. So we are not in a position, as it seems to me, to form a view as to whether there was the judge was wrong to say that the system was ineffective because it wouldn't have complied with the accreditation scheme. Because we don't know which measure of the accreditation scheme is said to be missing. We can't form any, as it seems to me at the moment, we can't form any view about that at all.
I don't argue, forgive me if it's not clear, I don't argue that the judge was wrong to find that because, well, I argue that he was wrong on the accreditation scheme per se, simply because the accreditation scheme is not the test. The test...
He said it's a very good system, better than most, but it wouldn't have complied with the accreditation system, though not by much.
Yes, but that is not, in my respectful submission, a relevant consideration when determining whether or not there was an effective system in place.
But with respect, what is a relevant consideration is what was said to have been deficient. Because take away the fact that, and at the moment, all we've got is a simple statement repeated. It didn't quite comply with accreditation. And then it says, I think you've got paragraph 20, lies in particular in the ability to check inside a vehicle, particularly one which is bearing a customer seal.
In my submission, that is what he said was deficient. Because if the learned judge found, as I've read, all of the other aspects of what he determined to be an effective system, and then later comments that it is defective because of the inability or the failure to check inside the vehicle at every stop, which is what he said, then in my submission you can infer that that's why he determined...
Ability to check inside a vehicle, particularly one which is bearing a customer seal. So that suggests, but doesn't say,
Wait, he's asking
that this... I'm sorry. This suggests, but does not say, that your clients effectively inherited a sealed container.
No.
If they didn't, if they were responsible for loading and sealing the container, albeit it had a customer seal on it, at the moment I don't understand. If they did the checks when it was loaded and sealed, and it was a customer seal, there is an argument, which I had understood you might be following, that they weren't, it would be wrong to say that they were obliged to go inside the vehicle again.
That is going in due course to be my argument. But I'm afraid that the code is dealing with two different types of vehicle here. A container is a separate box, such as we see stacked on ships.
Yes, I think I know what a container is.
Forgive me, I'm sorry.
No, you're right to assume I don't.
But the point being that those containers are always preloaded by third parties and loaded on ships and transported, etc., and almost invariably are sealed. And that is the reference in 1.1.8. In all other circumstances, we're dealing with hauliers who go to a collection site, open up the back of their truck and have goods loaded into it. And that is what the other aspects of the code are designed to deal with. 1.1.8
is containers.
My understanding is restricted to containers, which is why the Border Force are so concerned with the way in which they're checked, because they are loaded in the absence of the haulier, unlike in other circumstances.
So just I still don't know what is it alleged that your system didn't do? Is it alleged that your system didn't provide for checking when the lorry was loaded and sealed?
No. It is alleged that en route the vehicle was not opened and checked at each stop. That is the
inside.
That is the complaint that was advanced by the Secretary of State in the lower court. And that is the finding of the learned judge.
At every stop, including the last one, when it got to Dunkirk.
Including the last one.
So your error, if it was that you loaded,
Yes.
you sealed,
Checked and sealed.
you checked that everything was in order thereafter, that there was no sign of an infraction.
You have it.
But what you didn't do was go inside again the sealed container, it not being the sealed lorry.
On each occasion. I.e., what we did not do is when we stopped for our overnight stop at such and such a services, we walked around, we checked the cord, we checked the seal. What we did not do is break the seal, undo the padlock, remove the cord, and go inside the load area, check there are no clandestine entrants, come out, apply a new seal, padlock, a new cord, and a new seal. That is the criticism.
Paragraph 12.
Paragraph 12, thank you. Because that is the only way you can make that particular check if you need to check inside every time. And the point I raise about that, apart from the obvious impracticalities, is that it is not what the code of practice requires in one breath, but then does in another breath because it's so ambiguous on the point. And I set that out much earlier on in my skeleton argument. I'm loath to keep coming back to this, but this is the difficulty we face, and it is why, in one respect, we seek guidance on the topic, because there's no consistency in application.
The onus, though, is on the haulier to show an effective system.
Yes.
Leave aside what effective means.
Yes.
The haulier's got to show that there was a system.
Yes.
And that it had certain qualities.
Yes.
If the argument for the haulier is going to be this was an effective system, and it's impossible to argue that we should have got into the vehicle every time, broken the seals and resealed them, that's something that haulier's got to establish, including the proposition that the haulier's got to establish that by evidence. And if the argument is, as you tell us, and you may probably right about this, that there isn't any other way of checking the inside of this load than breaking the seals and going inside for a physical inspection. That again is something that's got to be established. It's not self-evident.
I would take, forgive me, a contrary approach. In establishing the system of prevention, one must establish all of the aspects that make it an effective system of prevention. The question, I would submit, is not, well, must a system of prevention involve a breaking of the seal on every occasion of going in and checking the vehicle? It's whether or not the system that is in place is effective for its purpose, and its purpose is prevention, where possible, and encouragement. And the difficulty with the proposition that goes, if you're going to break the seal every time and go into the vehicle every time, it's the same argument that we had earlier concerning if you're at the gates of Calais Harbour and you want to throw open your vehicle and go inside and check it. It's about practicalities. I accept that if there were a prescriptive requirement to go into the vehicle on every occasion, we would have no argument. But there is no such prescriptive requirement. What is required is that we must take, and it's said in Roth and in the body transport case, we must take such reasonable measures as we can to ensure we have an effective system in place. And if we take reasonable measures as are indicated by the judge in all other respects in this appeal, but we don't take that measure, we don't fail for want of an effective system when meeting the purpose of the statutory scheme. It's a, forgive me for...
Well, that depends upon whether going into a sealed container, which shows no signs of having been tampered with, a sealed vehicle,
yes.
Which shows no signs of having been tampered with, increases or decreases the likelihood of there being, when you get to Calais or Dunkirk, clandestines in it.
Yes.
Because if interim goings in doesn't actually increase the likelihood that there won't be clandestines in it when you get to the port, then your argument is, to my way of thinking, sound. Because it's no more or less effective, simply because you haven't broken the seal and opened it up every time.
Well, forgive me for in this terms, but I agree entirely with what my Lord says, because if you have a system which requires you to check the security of the till cord, that the seal is intact and not tampered with, that the padlock is in place, right, that the shell of the, then why would you want to go inside to make that one further check, safe in the knowledge that all you're doing is interfering with the very system you've put in place?
This is not for me to say, but the only thing I can think of is it's possible you might have missed the clandestines first time round.
Yes, of course. But by the same token, when you go in and check, it's possible you may miss them when they slip in again, when you're going around the front of the 50-foot long vehicle to re-establish your tilt. It's a chicken and egg. In the sense of whether or not the system is effective, if your initial checks demonstrate no interference, why would you want to interfere? Because that would increase, I would submit, at least the possibility of ingress. And if you identify, the whole purpose of going inside the vehicle to check it would be because you had been put on notice by your other checks that there was a risk.
Can we just go back to 1.2.5 again?
Yes. Well, no thank you, but yes.
Okay. So, well, I kind of agree. So the first part is what's the task? Well, the task is to check inside the vehicle. That's those first 4 words, right? That provide that's the first 4 words. Just hear me out. Hear me out. 1.2.5, right? And it says that can be done in a number of different ways. It can be through detection devices. And if you use a detection device, that doesn't stop you having to do 1.2.1 down to 1.2.4. However, where it's not possible to secure a vehicle by means of a lock, seal or other security device as a means to check the inside of the vehicle, because you have checked the inside of the vehicle, if you all your seals and everything are intact, then you have to conduct a thorough manual check of the load and the load space. Now, it's potentially rather torturous, but that would satisfy your case, wouldn't it?
It would. And I'm grateful for the clarification.
No, I'm not clarifying. I'm just trying to work my way through, trying to work out how this section, this clause works.
That is.
That would, you could apply that to your common sense approach.
You could, but in addition, it's quite clear that is not a check that is required upon every occasion, because the heading is specific. That is the check that ought to be conducted immediately before boarding the ship or vessel. But on a slightly separate point, and perhaps a little bit cheeky, one could argue, I submit, that an intact tilt cord and padlock and seal are of themselves analogue prevention devices. And so if one examines the analogue prevention devices and they indicate no ingress, then you've met the provisions of 1.2.5. The remainder of 1.2.5 is directed at those who, for instance, carry boats. There are people with boats transported in and out of the country on the backs of vehicles. Car transporter vehicles, all those vehicles that don't have 4 sides of roof and some back doors, is what I submit that is directed at.
Well, the short point is really this, isn't it? That last sentence, which is governed by where it's not possible to secure a vehicle by means of lock, seal or other security device, it is specifying the only circumstance in which check inside the vehicle applies if you can't use an effective detection device or haven't.
Yes, and to me that is the proper reading of that section of the code, and one of your detection devices is a seal and a tilt cord and a padlock.
Can I just picking up from that, have I got the structure right? It looks to me at the moment as if the requirements of the code, the prevention code, going to checking a non-customs or a non-container, because we're not concerned with containers,
a box.
Start at 1.1.2 and 1.1.3. So if you're present at the time of final loading, the owner, hiring driver must ensure, if not present, they must where possible ensure that such checks are carried out by reputable persons. And then when the final loading has been completed, you've got to shut it up straight away.
Yes, and lock it and seal it.
And lock it and seal it. The next one, it seems to me, at the moment, but correct me if I'm wrong, is 1.1.9. The same checking, securing, and according must be followed when the load space in the vehicle has been opened by the owner, and so on and so forth. And when a new driver comes on, he must do a check as well. That's 1.1.10.
Yep.
And then we get to 1.2.5, effectively. Well, again, please correct me if I'm wrong, but I don't think that says you've got to go inside the vehicle every time you stop.
Well, that's my analysis, and that's the analysis I seek to impress upon this court.
And was the criticism for Judge Godsmark simply that you didn't go inside the vehicle or the load every time you stopped?
Yes, and he says so in his decision.
Okay, if that can be confirmed, but it is accepted. You accept that you didn't go inside the load every time you stopped, because you say it's sealed, and your interpretation applies.
And the driver has done all of his other checks.
Yeah.
Yes. The Lord has it.
Have I got there eventually? Thank you.
If that be right, there ought to have been no penalty in this case, I would submit. And that's important for another reason. Because what His Honour Judge Godsmark did, having made that finding, is rule as a matter of fact that in respect of both appeals, the penalty ought to be imposed because the defence was not met for that reason. And if that were correct, then my submission is he fell into error. I spell it out in my skeleton. I'm not going to rehash it again, if you'll forgive me. But we must, I'm afraid, move on to the next stage of the process, which is operating the system properly on the day. In the Kaczynski, driver Kaczynski case, my paragraph 106 of the judge says this, paragraph 22. Fails in these two respects. Firstly, Mr. Kaczynski did not operate the system. He did not complete the checklist. In his deed, there is some doubt as to whether he did any check at all. Further than that, he was not properly monitored. Although monitoring is not part of the code of practice, it was part of the SCAT system. Thus seized not by Mr. Kaczynski or by those in the billing department who should have been operating the system that they themselves were saying was sufficient to prevent the problem with which I'm dealing. I make 2 points on those findings. This is in the system as it applies to the driver. The first is that of the incomplete checklist. I've argued the role of the checklist hitherto, and whether or not it can determine whether or not there was a system in place. And in any event, and again I've argued this as to the findings of the judge in all other respects, and whether or not the failure of the driver to do that what he did. And I would submit that that argument is reinforced by the approach taken by the Secretary of State, were this to be an accredited firm. The second point I would argue is that of monitoring, and again, I'd rather submit I've done it to death. Monitoring is not part of the effective system as far as the code of practice is concerned in prevention. It's a part of the level of penalty system. He goes on, the learned judge, at paragraph 23 to say this: it is said on behalf of the haulier SCAT they cannot be held responsible because somebody else this case driver Kaczynski, is a person who is not operating the system, and therefore there is no culpability on the part of SCAT. I found that B does not avow SCAT anyway, and so that is the learned judge going back to the earlier finding, which I take issue with for the reasons we've just touched upon. But in any event, I would not have followed Mr. Lewis' submission in relation to C. The words of the statutory defence are plain, and it is a requirement for the defence that on the occasion in question, the person or persons responsible for operating the system, that is the driver, did so properly. If the driver does not, the haulier is responsible because the statutory defence will not avail the haulier. That is the argument that I advanced in respect of the Secretary of State plainly taking a different view in terms of the accreditation scheme. She takes the view that if a haulier has done everything they can per this accreditation scheme, then they should not be penalised. And I'm not going to go over it again, but then we had a brief conversation about the O-cards at stop and the fact that there the driver had done, in His Honour Judge Godmark's view, everything that he ought to have done, i.e. he had an effective system, but his employer didn't. And that's all well and good, and I don't seek to argue that. But it's a reversal, and it's incongruous for that, of the position that the judge found to be in relation to the company doing everything they ought to have done and Kaczynski not doing what he should have done. And so the argument stands or falls there. We then go on to discretion. And again, it's about the exercise of the judge's discretion, not the Secretary of State's. At his 26th, the learned judge said this, that then takes me to the question of discretion. I accept this should not be used as a way of circumventing the statutory defence and perhaps filling in small holes that may have developed around it. So far as SCAT is concerned, there was an inadequate system, as I have found, but as I've also indicated, better than many, in my judgment, the relevant level of penalty, but not as to whether there should be one. If the system is deficient, they are vulnerable to a penalty. I agree, if the system is deficient, they are vulnerable to a penalty. It's whether or not discretion ought to be exercised. I forgive him, and I know His Honour will forgive me for putting it this way. Judge Godsmark's finding that, quote, an inadequate system, better than many, is relevant to the level of penalty only. If the system is deficient, they are vulnerable to a penalty, tends to reinforce the proposition that there's not really any discretionary power at all, because that is precisely where you ask the learned judge to exercise his discretion to impose or not to impose a penalty. So look at what the operator has done to follow the Roth-and-Bolly imperative, if one likes, considering encouragement, and to say they've done as much as they can. Is it right to penalise them in these circumstances? Because the discretion, of course, is to not impose a penalty, and in any event, the discretion does not go to level of penalty. That is a separate, I think, as we've identified, a different issue. Unless there are any questions, I don't suggest I've assisted you, but are there any questions?
No, thank you very much indeed.
Please reserve a right to reply
Of
if
course.
anything arises.
Of course you may. Thank you very much indeed. Yes, Mr.
Good afternoon, my lady, my lords. I start by noting that I take on board the observations made at the outset of this appeal that the bench is very familiar with the statutory provisions and the documents, and I will therefore go quite briefly, and perhaps on occasion only indicate where documents are rather than taking the court to them, perhaps in the hope that we might well conclude today, as my lady has indicated, would be preferable.
Well, it's preferable but not essential.
I'm grateful. I intend on structuring my submissions much as my learned friend has done and as has been done in the skeleton arguments, which is to address the general principles and general arguments first before turning to the specific appeals. And when coming to the appeals, I will continue to refer to them, labelling by the name of the judge who handed down the judgment.
Yeah.
I begin by making some very preliminary points as to the nature of this scheme. This is dealt with in section D of my skeleton argument, which the book needs not turns out now. But in paragraph 9, I make reference to the decision in International Transport ROF, which is at tab 7 of the authorities bundle. And I only mention it to indicate that this court in that decision found that the original regime was not compliant with the European Convention of Human Rights. And as a result, the regime had to be patched up, so to speak. And one of the primary ways in which that was done was by introducing an appeal mechanism. And in my submission, it's important to look at that appeal mechanism first. And the reason I say this is because I wish to make two arguments as to why some of the arguments that my learned friend advances today are not actually open to him on this appeal. If I could therefore ask the court to turn to tab 1 of the authorities bundle, which is the Act itself. And I would like to go to section 35A, which is at page 8, which is the appeal provisions that have been inserted subsequent to the decision in ROF. Section 35A1 says a person may appeal to the court against a penalty imposed on him under section 32 on the ground that A, he is not liable to the imposition of a penalty, or B, the amount of the penalty is too high. There are therefore only two grounds upon which you can appeal to the county court. You can't simply appeal and say in your appellant's notice that I understand why a penalty was imposed, but I think that it's unfair. You can only appeal on the ground that one shouldn't have been imposed in the first place, or that the amount of the penalty is too high. We then see at subsection 2 that on an appeal, the court has limited powers. Most notably, it can't increase the penalty, whereas the Secretary of State could. We've seen, and all of the judges below have acknowledged in subsection 3 that it's a rehearing and that it can be determined on matters that weren't before the Secretary of State, provided that they are relevant. We also note there that an appeal is to be determined having regard to the two codes of practice, and my learned friend has indicated that, as is actually agreed between the parties now, the code is not prescriptive, and that is a point that I will return to in more detail in due course. It follows from the drafting of this section that the county court confers on judges a wide power to make entirely new factual findings on the basis of evidence that was not before the Secretary of State, and it also confers upon the circuit judges hearing these appeals a very broad discretion as to whether to impose a penalty and the amount of that penalty. The Act does not, however, circumscribe in any way how that discretion is to be exercised, nor am I aware of any published guidance that tells the judges or the Secretary of State how to exercise that discretion. So the arguments that are advanced before this court are somewhat in a vacuum. One can only question them on ordinary grounds. Was this discretion exercised in a way that is clearly unlawful? For example, if the judge decided that because her family comes from Poland, she thought it not right to impose a penalty. Clearly, the discretion could be impugned on that basis. But otherwise, we're not given many indications as to the limits of that discretion. What these judges are doing is they are looking to make primary findings of fact. Was the vehicle sealed, for example? Was a checklist available? But then they are also asked to make evaluations of those facts. And one clear evaluative exercise is to ask whether the particular system was effective. And my position is simply that on an appeal such as this, even though it's a second appeal, this court should be slow to interfere, A, with factual findings, but equally slow to interfere with a judge's evaluation of the evidence before her. But I now turn to the two arguments of my learned friend, which I say, having read section 35A, are not open to him. The first argument is his argument about the adequacy of the Secretary of State's reasons. I wasn't quite sure prior to this hearing as to which reasons my learned friend was particularly concerned with. But as I think has become apparent today, that the reasons he's concerned with are primarily about the level of penalty imposed and how that particular figure was reached. But the starting point when considering reasons is section 35 of the Act, which is just on page 6 before. Section 35 2A says a notice must state the Secretary of State's reasons for deciding that P is liable to a penalty, state the amount, and then provide various further bits of information. It does not specify the level of detail that is required, and it does not specify that the Secretary of State has to set out exactly how a penalty is calculated. Now, I've made a point in my skeleton argument which my learned friend has picked up upon, which I don't need to advance further, but do maintain it, which is simply that this argument was not raised in seeking permission to appeal to this court, and it is arguable, or certainly my position is that permission was not expressly given in respect of it. I appreciate that this court can give permission now, so I won't take that point further, but I do lay down that marker. But I'm prepared to deal with the point on its merits in any event, and do so briefly. I deal with this point at paragraph 36 of my skeleton argument. And I hope that I've foreshadowed the basis of what I'm about to say, which is simply that on an appeal to the circuit judge, one cannot advance as your grounds of appeal that I'm discontent with the penalty that's been imposed because it contains inadequate reasoning. That is not one of the grounds. Similarly, if it's not within the circuit judge's power to decide not to impose a penalty for that reason, I submit that this court equally, although it has wide powers, does not have the power to do that because the statute does not permit it to do so.
You say that would have to be the subject to a public law challenge.
I do, my lord. And I would say, and I know that this is a point that's likely to be raised against me both in respect of this argument and the next argument, is that a point might be taken against the appellants that, well, you have a suitable alternative remedy, so you can't claim judicial review. But in my submission, this is a clear case where there isn't a suitable alternative remedy because you can't raise this point here. And in seeking to claim judicial review, you would make that point. And I might as well foreshadow my next argument, which is in relation to the criticisms that have been made of the code. If my learned friend is discontent with the drafting of the code, and to be fair to him, I'm not standing here saying that it's the most beautifully drafted piece of work, and it's not drafted by legislators. And in my submission, when we look at it, it shouldn't be analysed in the way that you would be analysing a piece of legislation. But if my learned friend wishes to say that that code is in any way inadequate, he has to bring a claim for judicial review to challenge it that way. This is not the forum to raise those arguments. And this is, of course, a code which has been laid before Parliament after consultation. So a document that has parliamentary approval, even if it's the negative approval procedure, still has some democratic legitimacy that you would expect would be challenged through appropriate routes.
The prevention code.
The prevention code.
Whereas the penalty code doesn't require consultation, but is again laid before Parliament.
Yes, my lord. So I say that's the end of the matter in respect of the challenges to the adequacy of reasons. And I've jumped ahead, but in any event...
Well, the adequacy of the Secretary of State's reasons.
The adequacy of the Secretary of State's reasons.
As opposed to any challenge to the reasons given by the judges on a rehearing, which is obviously within our purview.
Yes, my lady, precisely so. And the point that I make at paragraph 37 of my skeleton argument goes to that, which is that my learned friend relies upon a well-known authority that is a practice note directed at professional judges as to the reasons that they should give in their judgments and how they should approach arguments advanced by counsel. So I'm not entirely clear why this authority has any relevance whatsoever to the argument which he makes. It might be because it was referred to, I think, in the Bowl case, but that was because the court was considering whether the circuit judge should have been asked to improve his reasons rather than for the matter to be appealed. But my submission is simply that if he's relying on that case, I need not take you to it, but it has no application whatsoever. He does rely upon a case, and again, I'm arguing the merits here, even though I say that this shouldn't arise for a couple of reasons, but I can deal with the merits very briefly. He does rely on a case which is of more relevance because it concerns the duty to provide reasons of a public body. And that is the case of Asher, which is in the authorities bundle at tab 8. And I would ask your ladyship and your lordships to turn to paragraph 24, which is relied upon by my learned friend. I need not read it out in full, but I do pick up this. The court says that as a matter of good administration and fairness, the body concerned should give such reasons as are appropriate and reasonable in the circumstances. And then a bit further down in the paragraph, it goes on to say it is important that that body should have a reasonable and practicable opportunity to satisfy itself that the decision has been properly taken. So when a public authority makes a decision, the person who is affected by that decision should obviously be in a position to challenge it. And that is a relevant circumstance. In paragraph 38 of my skeleton argument, I make submissions and give 4 reasons as to why I say the reasons provided here are adequate. I note that, of course, these are decisions made by border force officials. They're not made by lawyers. They have to make hundreds of such decisions, and they shouldn't be expected to lay out reasoning in great detail, certainly not reasoning of the standard that a judge would provide. Second, I note that the penalties are provided in standard form. That might be a point taken against me, but the reason I raise it is because they do set out the necessary information that one needs to understand the nature of the regime and the penalty itself.
Can I just ask you, see whether I've understood the nature of the document correctly? Because the reasons with boxes with what look like fairly standard form sentences added all go to penalty. And is my understanding about that correct, that the liability to be subject to a penalty depends simply upon the finding of the clandestine entrant? That triggers the whole scheme, and it is for the haulier to establish the defence. So the document doesn't go into that at all.
Yes, my lord.
Which is why you only see what one could call reasons of any sort in relation to penalty.
Yes, my lord.
Have I understood it correctly?
That's correct. It's a point that my lordship raised with my learned friend earlier today about how you have liability and then the defences. Similarly, the fact that you have entrants means that you're liable. That's it. If there are entrants on the vehicle, that's all you need to state. There were 5 entrants on the vehicle. You then move on to the defence. But the reasons go to penalty and why a level of penalty has been imposed, but they of course are relevant and they provide insight into the Section 34 defence. Because your lordship asked me before the lunch break whether we accepted in the fine appeal that whether or not there was an effective system in place, and I'll deal with that in due course. And we say that there wasn't an effective system, and the reason why is that there was a failure to monitor, and that is set out in the boxes on the penalty. So even though that is going, those standard form boxes are primarily addressed at why a penalty has been imposed and the level of it, they do give the reader insight into matters which explain why the Section 34 defence would not be available to them. So I've pointed out that these aren't drafted by lawyers, that the reasons we've discussed the standard form point. The next point, of course, is a matter that we haven't touched upon in this appeal, and we need not do so. But you do have a right to object. You have a right, it's a cost-free right of writing into the Secretary of State saying, you've accused us of not having instructions for our drivers, here's a copy of them, please, please revise our penalty. That's cost-free, it doesn't require lawyers, and it's used frequently. Even if that's not the case, and that's not enough, we now have appeal hearings, which are complete reviews where you have a fresh opportunity. And my learned friend, I don't think will correct me on this, or perhaps his learned junior is more familiar with it, but in these hearings, the Secretary of State adduces evidence, usually of one of its officers, which sets out in greater detail than in the penalty notice some of the considerations that have gone into making the decision. So the further information is given at a later stage. So unlike many public law challenges where there's no right of appeal at all, so reasons take on a heightened importance, that is not the case here. So in summary, on this point, I say my learned friend can't raise adequacy of reasons because there's no jurisdiction to do so. I also say he hasn't got permission to do so. And then I say that if he can raise them for whatever reason, in the circumstances of this regime, the reasons are adequate. My next point I can take briefly because I've already indicated my position, which is again the attack on the quality of the codes. This is expressly raised as grounds of appeal in the SCAT appeal, the Godsmark appeals. And for all the reasons which I've made, and I don't want to repeat, so I'll leave it there, I say that those points simply cannot be raised now and here. I then turn to the Prevention Code generally. I deal with it at paragraph 13 of my skeleton argument, but we need not turn that up. The court will have seen that, of course, it's made under section 33 of the Act, and my lord has indicated that one is required to consult upon it. I understand that the road transport industry was consulted at the relevant time. It was laid before Parliament, and I understand that it was in around March 2004 that the codes came into effect. Fortunately, my learned friend and I agreed on one proposition here, which is that the code is not prescriptive.
What do you mean by that?
Let me develop that, my lord. In answer to your question, I mean this. When determining an appeal, under section 35A3, the court has to have regard to the codes. Similarly, when determining whether there is an effective system in place, under section 34.4, regard is to be had to the codes. Those words were quite carefully chosen, it seems. The drafters could easily have said are bound by, have to follow the codes, but they did not. It's clear from that wording in my submission that Parliament did not intend either the Secretary of State or the court to be tightly bound by its provisions. However, I follow that up with this important caveat, that it goes without saying that where this code has been consulted upon, the Prevention Code, laid before Parliament, and experts have considered it, naturally the Secretary of State, her officials, and more importantly the court, should give it substantial weight. I think my lord asked my learned friend about this earlier. Now my position differs from his in that I say it should be given substantial weight. A judge confronted with this regime with no previous familiarity with it should be very slow to say that I don't think that that's a good idea, despite the fact that Parliament did.
So if we interpret the code as not saying that you should check the inside of a vehicle at every stop, what should we make of that?
My lord, it would be open to the court to say that, stepping into the shoes of the circuit judge, this court has read the code, can't make sense of that provision, and is deciding to depart from it, and does not think that checking inside the vehicle is a necessary requirement. I'd say that is open course open to this court.
And if we did that, then we allow the Godsmark appeals, and that's that.
My lord, I would have to reflect upon that just to check whether there are any other issues.
Whether you can find some other way around it.
I'd like to buy some breathing space in which to look for one. But my lord, I would say that it is important to accept that whilst this is a theoretical possibility, it shouldn't happen very often. And it's perhaps at this stage, I was going to deal with it in the fine appeal, but I will deal with it now because we're discussing this, which is 2 points. The question, perhaps the major point made against me in this appeal is that the requirement to monitor does not appear in the Prevention Code. And I need to deal with that head on. But perhaps I'll start at the opposite end of the spectrum and make a point that I could see that the bench was not particularly impressed with earlier and perhaps would like to try and refine my answer somewhat. And this is the case in which Her Honour Judge Fine, for some reason, decided that even though the code did not require drivers to go around taking photos with their mobile phone, that would be quite a good idea. And when my lady asked me whether she was entitled to do so, I said yes. And I stick to that answer. But
Well, you went further. The judge can make it significantly more stringent than the code if she chooses to. Seems a bit hard on the whole, is it? But
yes, it does.
It's your case.
And let me provide a much needed clarity in respect to that, my lady. The first point is one of simple practice and procedure. Obviously, a first instance judge should rarely, if ever, make findings where neither party has made any submissions on them and there's no evidence before that judge. I can't resist.
Rarely?
Well,
judicial notice.
Judicial notice.
Yes.
And there might be occasions where judicial notice is appropriate. But I wasn't involved, and I don't know, but I take it from what my learned friends junior indicates that the Secretary of State does not make any arguments to this effect. And in my own experience and from instructions, I would think it highly unlikely that the Secretary of State would turn up to an appeal in the county court and tell a judge or invite a judge to go beyond the code significantly, or raise a matter that had not been raised in a penalty itself. So for that reason, I think perhaps the judge erred slightly there in going beyond what she was asked to consider. For reasons that I'll get on to later, I say her discussion in this regard is obiter and doesn't change the outcome of the appeal. But I have to emphasize that because one only has to have regard to the code, it is a theoretical possibility that a judge, in particular circumstances, if invited to do so on the basis of cogent evidence, was invited to find that there was not an effective system. The statute clearly entitles the judge to take that course. Similarly, the statute entitles the Secretary of State to take that course in deciding whether a system is effective or not, because she only has to have regard to the code.
Well, speaking for myself, I find that easy to accept because these codes, this one, you tell us, is 17 years old, not been updated. Well, things change. That's one simple way in which the code might not be a complete answer on the facts of a given case.
Yes, my lord, and I should say I'm afraid I can't assist the court with the details, but I believe there was some consultation on the code back in 2016, but I don't think it came to anything. Speaking of judicial notice, I would ask the court to take judicial notice of the fact that obviously parliamentary time is scarce, and whether, I don't know the difficulties in getting a revised code before Parliament. Clearly that's not been the approach that's ultimately been taken, because it seems from the bill that there will be properly drafted regulations that will hopefully cause less confusion. But
It'll be harder to amend.
it will be harder to amend, and perhaps that's why codes were used in the first instance. But it is the case, as my lord points out, this is drafted in 2004. In those days, we didn't have as many mobile phones that could take pictures. It might become a requirement, and it might work well. So the point that I'm making is that it is a theoretical possibility, but it's not only theoretical. I have to accept that the Secretary of State has done this. I have to accept that the Prevention Code does not expressly require the monitoring of drivers' performance. But my position on that is that the fact that it is not contained in the code does not bar the Secretary of State from finding that a system was not effective for a failure to monitor. I also have to accept, it's a matter of common sense, that it would perhaps be helpful, it would be helpful, if this is an important requirement for it to be reflected in the code.
Well, it goes a bit beyond that, isn't it? Somewhere we need, it's all very well talking about monitoring, but we've heard about various different levels of monitoring. You can ring your driver every day, you can get him to ring in, you can have the telematic scheme that we've now know a little bit about, and so on and so forth. If this is not a JR challenge, this is just a simple thing of how you're meant to interpret this day in, day out, and what is meant by effective or ineffective. There needs to be some clarity somewhere about what is thought to be the current good practice, but there's nothing, is there? So it's not merely that monitoring isn't mentioned. If monitoring was mentioned, just the word monitoring appeared, it would be almost impossible of application.
I would accept that, my lord. It would be very difficult even if it was mentioned. And it seems, of course, we're not concerned with the bill, but I think what the bill does is it gets rid of speak of an effective system. Just says this is what you have to do. They're set out in regulations, no question of whether it's effective or not. So hopefully that will be remedied. But in terms of monitoring, I say that it's not a goal for my learned friend that it's not in the code. The Secretary of State is still entitled to impose penalties for this reason. And it's interesting that in the Godsmark appeal, in which 2 penalties were under consideration, my learned friend took us to paragraph 22, and we need not go to it again, just simply to note that monitoring was part of SCAT's appeal system, SCAT's own system. So the haulage company itself required itself to monitor its drivers' performance. And it's a common sense matter. If you accept that drivers have to carry out various checks and so on, and if the court were to accept my proposition that a haulier is liable for the actions of its driver, then it's common sense that one would monitor their performance. And if a driver wasn't performing, or you found that he was lacking on a particular day, you would take disciplinary action, which ultimately might lead to fewer penalties being imposed upon.
It might be said, though, that at least when it comes to penalty, assuming the Secretary of State is entitled to argue monitoring, the haulier could say, well, you never told me that was something I had to do to have an effective system. And it would be quite wrong to impose a penalty for a deficiency or a falling short of a requirement that you never mentioned.
Yes, my lord, but the difficulty with that is that the Secretary of State would say, well, look, if you look at the penalty code, which tells you how penalties are formulated, that expressly does refer to monitoring of compliance. So you'll see in at least one of our codes that we think monitoring your driver's compliance is an important matter. I accept it's not as good as having it in the Prevention Code, but it's not a concept completely foreign to both codes. And any haulier would know, if they read the codes, that absence of monitoring would no doubt lead or could lead to a higher penalty being imposed.
Or the presence of monitoring could lead to a lower penalty. So it's consistent with monitoring simply being a factor in mitigation if you use a criminal approach.
Yes, my lord.
It's not of itself decisive as to whether or not the code is effective.
My lord, I would say whether a system is effective is quite a complex question, one feature of which would be whether I would say there has been monitoring of compliance. So I would say it's both part of an effective system that there be monitoring of drivers' compliance and its relevance to penalty size. Whilst discussing the code, and I hope to go quickly here, I might just deal with a couple of points that we've already touched upon and take them quite quickly. The code itself, the prevention code, is at tab 3. As one can immediately see, it's not drafted as I've described in the form of any statute. And I'd submit that there's limited benefit to scrutinising its provisions as if they were the provisions of a statute. I note very quickly on page 31, there's reference in the final paragraph to paragraph 1.17 to seals, and then they have to be distinguished by a number from a series which is unique to the owner, and so on. This must be recorded in documentation. So seals is not in dispute as an important part, sealing vehicles. Then section 1.2, and again I have to confront a difficulty in the drafting of this. Section 1.2 says measures to be taken immediately prior to the vehicle boarding the ship. I've taken instructions on this, and the Secretary of State's position is that this is concerned with steps that have to be taken the last time the vehicle stops before boarding a ship, actually has a stop. That might be at a petrol filling station 20 miles away. It might be elsewhere.
So the word immediately is superfluous, is it?
Yes. Again, the drafting, those are my instructions. What my client is looking for is the last time that you stop your vehicle where it's possible to carry out a thorough search, and it's not dangerous to carry out a thorough search, you carry out these inspections. Because as you indicated...
And presumably it doesn't increase the risk of clandestine entry.
Yes, my lord. And as you pointed out this morning, if it was the case read literally, immediately prior to boarding the ship, you would have lorries backed up for miles, and that would create chaos. And that's not what my client is seeking to achieve here. And to be fair, my client's position is that she is trying to encourage compliance with a system that addresses a social evil, as it's been described. She is trying to work with the haulage industry to achieve measures that reduce the scope of this problem. She's not trying to make things overly burdensome by this code. All that is suggested is that the last time, if you're at a petrol station and that's the last time the driver's going to be getting out and has an opportunity, he should check the inside of the vehicle. And we've had debate as to the meaning of paragraph 1.2.5, and I can see, I have no further submissions on that. It's clearly not particularly well drafted. But again, my client's position is that at that final stop, which might be 20 miles away, you should check the inside of the vehicle. The fact that a customer has applied a seal is really not a problem, because seals are applied and then new seals are put on. The fact that your customer tells you, well, the customer has a seal on, doesn't mean that you can't break that seal, inspect inside, and then put on a new seal. And my lord, I think, raised a question this afternoon about what the point of checking inside might be. I think it might be the case that in one of these appeals, the method of entry wasn't known. So it might be the case that doing all of these checks might not be sufficient to identify entrants in the vehicle, which is why there's this one additional step. But given the poor drafting on this, I can step back and say this, that I have accepted already that this code is not prescriptive. A judge is confronted with this. Submissions may be made to the judge as to what it means and what was done. And that can be addressed both in oral submissions and as to evidence. Evidence explaining why a seal cannot be broken. Evidence as to why it shouldn't have been broken on this particular occasion due to particular threats.
Well, the only evidence we've got, I think, is the good SCAT driver who said that you shouldn't break a customer seal without very good reason.
Yes. So Mr. Alcaz made it quite clear that this wasn't his own personal preference. He had been instructed, and I don't think this is in dispute, SCAT had told him, do not break a customer seal. And that is why His Honour Judge Godsmark decided that obeying the customer's command there rather than the penalty code was not the right way to go. And I say that the judge was entitled in his evaluation of the evidence to reach that conclusion. And if these words could be interpreted in different ways, again, it was open to the judge to do so. I can understand my learned friend and key practices in this area more than I do, frustration, and I can see that one would want a better, or as my Lord indicated, further details in respect to monitoring and so on, and this might give rise to frustration. But in my submission, I understand that this is a second appeal, but I submit that this court can't, and this is a submission I don't enjoy making, but can't do the legislation, can't plug the gaps for these documents. It can apply the law and apply the statute and apply the regime, but it can't give guidance as such, saying that in this court's view, an adequate level of monitoring requires you to do A, B, and C. And in this court's opinion, it's not necessary to check a vehicle prior to loading for these reasons. Whilst, of course, it would be of great benefit to the county courts to have the Court of Appeal deciding those matters, I submit that it simply doesn't have the material before it to make those decisions. I then turn one final point on the Prevention Code, which is on the following page, which is page 33, and to 1.3. And the court need not look at my skeleton here, but it's dealt with at paragraph 17. I explained that where we talk of a security checklist or a checklist, that's just shorthand. There is no prescribed form as to how this should be done. What is required there is a document detailing the system operated. And as my learned friends indicated, the Secretary of State provides a pro forma, and that is often used. And one of the central submissions that I wish to make in these appeals is this, and it flows from an observation made by Lord Justice Males in granting permission, is that the relevance of a security checklist is not that it provides evidence of an effective system. Rather, a checklist is part of an effective system. In order for a system to be effective, drivers need to fill out a checklist as they go along.
Probably both, isn't it? It may be part of an effective system and evidence that there is such a system.
Yes.
And it's being operated.
Yes.
Or not.
Certainly, my lord, I would agree with that. My concern is that it's not a case that the checklist doesn't matter because I have an effective system in place, so you don't need to bother about the checklist.
Speaking entirely for myself, I don't need persuading of that. No. The importance of a checklist as a trigger, stroke reminder, stroke whatever for the driver.
I'm grateful, my lord. I'll move on. The only further point I would make is one raised in oral submissions by my learned friend, is I accept that the code does not say you have to produce it on demand. However, that is important and it is implicit. There can be no reason why a driver cannot produce a checklist on demand. We're all in agreement that it has to be filled out as you're going along. It's not something that's completed after the event, and indeed it couldn't be done after the event because you wouldn't have details of times and places. So it should be with you. The failure to produce it is relevant for evidential purposes. Now, I stress that no accusation is being made in these appeals at all, but it might be the case that when confronted with a penalty, a haulier or a driver might want to produce a checklist after the event. That's just a risk. It's not an accusation being made here. But the evidential value of producing a checklist on the day when there's no reason why you shouldn't have one is enormous. There are appeals, and there aren't in this case disputes of fact, but there might well be, and I believe I have seen cases in which there have been such disputes. Producing a checklist provides certainty that it was done at the relevant time and not after
Well, we do have it in one of the appeals, because in one of the appeals, the border force person wasn't satisfied that it was contemporaneous, and the judge was.
Yes. So yes. So there, the judge was satisfied on perhaps further evidence than the border force officials saw. But yes, different findings can be made. But my lord, it goes without saying that if it's produced on the day, there's just less room for doubts in this regard. And that's a factual finding that the judge made, and I don't seek to impugn. I now turn to the section 34.3 defence itself, and we've laboured this, and my learned friend has made a concession, so I will take it particularly quickly. I've already made the point that deciding whether there's an effective system in place is either a finding of fact or it's an evaluation of fact. And on these appeals, even though they're second appeals in which the court might provide guidance, one is still looking at the judgments below. And one has to decide whether their discretion and their evaluative findings of fact can be impugned and on what basis. My learned friend has complained in a skeleton argument at various times that that companies are at the mercy of their drivers, and that this is iniquitous to punish blameless hauliers for their actions of their drivers. I think he now accepts that he's in some difficulty here on the first argument, simply because the wording of the statute simply says all three limbs have to be dealt with. But in any event, as the court has indicated earlier, I would say that this approach is in line with the scheme as a whole. There's joint and several liability for a driver's actions. We know that a faultless haulier can be liable to pay the penalty imposed upon a driver, whether it's at blame or not. It is a responsible person, and Parliament thought it best to make sure that a haulier was liable for the actions of his driver. As the court has raised with my learned friend, it's not a question of vicarious liability or common law principles, it's just what the statute says. And in any event, as Her Honour Judge Fine pointed out, if it was vicarious liability, why wouldn't a haulier be liable for actions taken in the course of a driver's employment at its instruction? So it follows in my submission that the driver and the haulier stand and fall together. They either both can avail themselves of the defence, or neither of them can. They're both reliant upon each other. But that doesn't mean that it's the end of the matter. I do accept that even if the statutory defences are not made out, the court and the Secretary of State holds a discretion as to whether or not to impose a penalty. And it may be the case, like His Honour Judge Godsmark did in the case of Mr. Alcaz, that where there is a lack of culpability, that might be a reason for not imposing a penalty. And that is a matter within the judge's discretion.
Is it necessary for a judge to say, I first decide to exercise my discretion to impose a penalty, and the penalty another stage penalty I'm going to impose is this, that, and the other? Or is it sufficient for a judge to say, in my judgment, this calls for a penalty and the penalty is X? Does the judge need to do more than that? I mean, he may have to explain his X, but...
Yes, my lord. I think one would follow the formulation provided by Lady Justice Gloucester at paragraph 36 of the Bowl.
For safety.
Sorry.
For safety.
For safety. Yeah. So one would look at it, say, is there an effective system? If not, I have a discretion. Should I impose a penalty on the driver? Should I impose a penalty on the haulier? Then if yes to either of those, what should that penalty be? Okay. And I accept that there might be some overlap between the two. The mitigating and aggravating circumstances going to the level of penalty might be equally relevant to whether I should impose a penalty in the first place.
And would you say also that where there's been accreditation, well, we know that when there's been accreditation and there's an effective system, then there's no penalty, because that's the policy. Would you say that fairness demands that exactly the same applies if there's an effective system, albeit that it's not been registered for accreditation.
My lady, this is a point that's been raised today in this appeal for the first time, so I don't have firm instructions. But my answer would be this, and I speak slightly in ignorance as the ins and outs of the accreditation system, and my learned friend would know it better than I do. But accreditation involves the Secretary of State giving a thorough review of your systems and deciding that they are really tight and really sufficient, such that you get a pass and your system is decided to be effective. I don't know what's involved there, but the fact that you've got accreditation doesn't mean that and that is a pre-approval of your effective system, doesn't mean that if you don't have accreditation and you have an effective system, you should be treated the same way. I see, my lady, that
if you have a judge that makes a finding of fact, having had a thorough examination at a rehearing,
yes,
that there's an effective system, you say that that isn't up to the same mark as the accreditation, and so you shouldn't apply the same policy or the same approach, I should say, not policy.
Well, my lady, I don't know if the court's conclusion and the matters it would take into account are as thorough as the Secretary of State. They may be, I don't know.
But the fact remains, in both cases, there's been a finding that there's an effective system, or an acknowledgement acceptance of an effective system for the purposes of Section 34.
Yes, my lady, I have to accept that. All I would say is that perhaps there's some greater favour that you receive by participating and
so you don't exercise the discretion as a sort of reward for filling in the accreditation form, whereas if a judge makes an identical finding, you don't get that reward because you didn't fill in the form.
My lady, I raise it as a possibility. I don't have instructions, and I don't know how the Secretary of State, as a matter of fact, takes
the possibility I think you're raising is that the accredited people are a Premier League of effective systems.
Yes.
And the ones who've only got the benefit of a finding from a circuit judge are just the Championship.
Yes. And I don't know, my lord, if
so they don't get as much money from Sky TV, namely relief from penalties.
And not know whether they're meant to be in the Premiership or not. But there's just one slight permutation. You could have a situation where, in this case, the Secretary of State has accepted that A is satisfied. You could have a case where the Secretary of State says A and B are satisfied. And you're not accredited, but there's no issue. And it's down to C. I don't know what anybody's meant to do in those circumstances.
Yes, I have to say it.
Depends if you're in the Premier League or the Championship.
Yes, my lady. I accept what my learned friend says, that there might be some tension in the way that Judge Godsmark dealt with matters. But my position is that the circuit judge certainly has a discretion where the haulier is blameless. And it's quite difficult to work out where that boundary is, because, of course, if the driver's at fault, it might partly be because he lacked adequate training and so on. So it's not a clear-cut division between who's blameless and who's not. But if it is found that the haulier is blameless, I say that it is open to the court and open to the Secretary of State not to impose a penalty for that reason. And that didn't happen here. It was certainly not before His Honour Judge Godsmark. But one then, in this court, has to consider whether the exercise of His Honour Judge Godsmark's decision should be impugned on the basis that it was perverse or not open to him or flawed by some legal error. So it might well be that my learned friend, and indeed this bench, might have decided the case differently and not imposed a penalty on a blameless haulier. But that is not a sufficient basis to overturn the exercise of his discretion.
Well, I think that's why we're niggling away at this point. Because if the suggestion implicit in my lady's case is right, and there's nothing really to distinguish someone who is passed because they're accredited and someone who is passed because they've passed, then we might be getting into territory of saying His Honour Judge Godsmark, despite the fact this was, as I understand it, not argued in front of him, fell into error of principle.
Yes, my lord, I can appreciate that. My only difficulty is this, and I'm very slow to raise a procedural point, but this is something that has emerged at today's hearing, and it is a matter of which I don't have familiarity factually as to how it all operates, and it was not one of my learned friend's grounds of appeal. Had he advanced a ground of appeal along the following lines, that there's an accreditation system, it amounts to some form of policy or statement, and His Honour Judge Godsmark did not follow it or acted contrary to it, and therefore committed an error of law, my client would have responded to that on this appeal. And I can see why it might be raised in an argument, but I simply say that it has not been here. And I would need further instructions and certainly factual material, and I don't know the extent to which points were argued about accreditation, its nature and its standards below. It might even be the case that both parties would need to adduce fresh evidence following the Ladd-Marshall rule, which it probably wouldn't overcome for this appeal, but would need to adduce new evidence to deal with this matter. So whilst these matters come to this court very, very rarely, and we have an opportunity here, I would say that this is not an occasion on which the court should consider making a finding on that basis. The next heading in my skeleton deals with what is an effective system, which I suspect we've done to death and I don't have much further to say about. My learned friend, in his skeleton argument, raised a question about the interaction between Section 33(1) and Section 34, saying that they were inconsistent. I don't propose dealing with that because I think my learned friend and I are agreed that it's not prescriptive. So I didn't quite see how that Section 33 point assisted him. So unless the court has further questions, I turn very briefly now, and should have plenty of time to do this, to deal with the three appeals themselves. I start by saying...
Anything else on the substance? Anything else? No, thank you. Move on to the appeals.
I start by saying that these appeals are dealt with in busy court lists. The three judgments that you have before you are all given extempore after very short hearings, some of them online. And one has to look at the judge's reasoning, having some sense as to the pressure judges were under and the level or the quality of their reasoning. And I make that point at the outset. If we could turn first to the fine appeal, which I deal with starting at paragraph 39 of my skeleton argument. At paragraph 40 of my skeleton argument, I set out why the Secretary of State imposed penalties. We see on link because of the failure to monitor and so on, and in respect of the driver because the lack of proper securing of the tilt cord. Then both parties appealed to the county court, and the thrust of that appeal was that given that there was only inadequate monitoring, that wasn't a good enough reason to impose a penalty. And I've dealt with that matter and won't rehearse it. Both appeals were dismissed by Her Honour Judge Fine. If we turn briefly to the judgment itself, that appears in the core bundle at page 67. We see at paragraphs 16 and 17, the judge deals with what is an effective system, and we've dealt with that. One matter I do want to deal with is this tick box allegation. Now, I have to say again, I think my learned friend and I are agreed upon one matter here, which is that if the judge was denigrating the use of a checklist and the Secretary of State's pro forma, then we're in agreement that that was unfounded. But in my submission, when you read what she's actually saying here, that's not her criticism. Her criticism is not that a checklist was used or that it was ticked off. What she is effectively saying, although she didn't use these words, is that the driver simply went through the motions. He filled out a checklist without checking. The way that this is set out...
Where are you looking? I'm sorry, where are you looking?
At paragraph 17 and 18. So in 17 she says, the relevant tick box form was analysed and approved by the company as having been correctly completed by the driver. The problem with the incorrectly installed tilt cord was not identified. And as I understand the judgment, is that he checked, but in checking didn't discover this problem and filled out, just ticked the box unthinkingly.
Doesn't say that though.
It doesn't say that, my lady, and I accept that that's not what it says, but the way that I read this, and perhaps it's the wrong reading, in which case my learned friend and I are in agreement that the company should not have been criticised for using a checkbox. But she says, that even if it was known, the relevant tick box form was analysed and approved by the first appellant as having been correctly completed by the driver. So correctly completed. And that's where I draw that from. And then she goes on in paragraph 18, referring to the bundle, says that the tick box had been incorrectly filled in by the second appellant. And that when the company checked it, and again, my lord raised questions before the luncheon break as to how the company was supposed to check it. I don't know.
But it then says the first appellant had no effective way of checking that the vehicle had been properly secured, and that's the use of the checklist. And if you're saying the use of the checklist completed by the driver is insufficient and you should have videos and so on and so forth, that is denigrating the checklist, isn't it?
My lady, if that is what the judge is saying, then I have to agree. The way I read this is that what she was saying is that the checklist had been used. Use of the method of the checklist as a method of securing the vehicle was not problematic, but what was problematic is checking and not seeing that there was a problem and ticking off the box. And perhaps it's that we simply don't have enough facts from this judgment to work it out.
But it all starts with a criticism of the appellant's system of checking on the driver.
Yes.
It's not about the driver's inadequate attention to detail.
Could we have the page references in the files that we've got for page 45 and page 48, which are referred to in paragraph 18, please?
Yes, my lord.
Not immediately, but before we go. Thank you.
My lady, I can't take it further than that. If the judge was denigrating the checklist, I don't think that she was correct to do so.
Well, it's just that it says the appellant's system of checking on the driver was not an effective system, full stop. It relied on the driver completing a simple tick box form with no effective check at each step.
Yes, I accept that that might well be the gravamen of her complaint, which is why she perhaps went further and wanted videos taken of the vehicle. And I've made my submission.
No, you have them very clearly,
that.
thank you.
We've dealt with, at 22, she deals with monitoring. I've made my submissions, but equally this judge thought that monitoring was important. She makes reference in paragraph 22 to being rejecting the argument that the driver was a frolic on his own. I've indicated that I think that if there was a question of vicarious liability, he would be so liable. Then I have to accept in paragraph 23 that the judge does seem to misstate the test. I don't think I can resile from that. She says the next issue is whether the Secretary of State exercised her discretion appropriately not to impose a penalty, and we know from the decision in bold that that is not. But perhaps a slightly brave submission to make. I hesitate to say that perhaps this isn't entirely what the judge meant, because if you carry on reading in that paragraph, she says, I find it is proper to exercise the court's discretion to impose a penalty in these circumstances.
Well, the first sentence, 23, is perhaps one way you might say, was the Secretary of State wrong to impose a penalty in the exercise of her discretion, which is the question for the court.
Mm-hmm.
The word is appropriate.
Yes.
This is not the language of judicial review. I mean, when I read this, I could see, you're quite right, the first sentence doesn't very well identify the test. But she does go on, as you point out, to identify the court's discretion
Yes.
as what she's doing.
Yes.
So I think there is something, perhaps, in what you're saying, in an extempore judgment in these circumstances.
I'm grateful, my lord. The remainder of her judgment is dealing with the level of penalty. And we see that she does address various factors at paragraph 24. And then I think my learned friend has taken issue with her finding of fact, or her treatment of the evidence as such in paragraph 26. I don't need to make detailed submissions on that, simply to say the judge was confronted with some financial information about this driver. She found it to be inadequate because she was concerned with his means, not just his income, but whether he could afford to pay this penalty. And whilst it might have been a harsh decision, it remains a case that it was open to her. It's a simple finding of fact. I then turn to the co-appeal. And again, I can take this quite quickly, given that we've considered most of the issues that have been raised in it. I deal with this at paragraph 55 of my skeleton. Where I set out why the Secretary of State imposed the relevant penalty. The key issue here is one that we have already discussed, which is the relevance of providing a checklist at that time.
Yeah.
And the judge's judgment is at page 144. And we see that paragraph 9 on page 146, she says, "It does seem to me that the failure of the driver to provide a checklist at that time does amount to a failure to meet the requirements." It's not clear to me how the further statement about mitigation relates to the first. But she is finding, as a matter of fact, that it wasn't produced at the time. And I would say it's implicit in this that it should have been produced at the time had it been filled in. And whilst I accept that the code doesn't expressly require you to hand it over, it doesn't say that, there should be no reason why you shouldn't be able to do so.
But it doesn't make any difference to the effectiveness of the system, whether you hand it to the border force person or whether you produce it later and the judge accepts that it was contemporaneous.
I have to accept that one.
So,
yeah. Again, this is a case in which the wording in relation to imposing a penalty is perhaps slightly wanting, in that in paragraph 11, it says, "It seems to me that a failure of the driver to produce a checklist is a feature which could entitle the Secretary of State to impose a penalty." The question is whether this judge wanted to exercise that discretion to impose a penalty. And in my submission, it was open to her to do so on the facts before her. She wasn't committing any error of law in doing so. And equally, her decision as to the level of penalty, which was significantly reduced to a quarter of its maximum £500, was also open to her.
Do you accept that the failure of the driver to produce a checklist referred to in paragraph 9 is the basis upon which she held that the system was ineffective or not effective? Or do you submit that there is another finding that it's not effective for a different reason?
My Lord, I don't believe that there is another finding, because this is a case in which the judge reached a contrary view on the basis of additional evidence to the Secretary of State, in that she didn't think imposing a penalty, she considered the company's monitoring of its drivers' compliance to be satisfactory. And perhaps it's useful in answering my Lord's question to turn to the penalty imposed upon it, which contains the relevant details, which is only a few pages on at page 166. There is only there reference to a failure to monitor, and it doesn't describe any other failing of the effective system other than the checklist not being available.
So you're not submitting that the failure by the driver to produce the checklist at the border is a failure to implement the system under C, coming into 34(3)(c.
My Lord, I answer with some hesitation there. One would think that if drivers are properly instructed to carry out their duties to fill in a checklist and so on, they would be instructed to provide those checklists.
She has not found that.
She has not found that.
She's not found an absence of proper instruction. All we've got.
But my Lord, I have to accept in this short judgment, she doesn't identify another failing as such.
Well, she certainly doesn't. I think you've accepted, very frankly, she doesn't accept a failure under B. All I want to be entirely clear with, and I'm going to ask you to say yay or nay, is it the Secretary of State's case here that the failure by the driver to produce the checklist at the time, even though it had in fact been contemporaneously filled out and was produced later, is of itself a breach of the requirements to operate under C?
My Lord, my answer would be yes, it is a breach for this reason. In that, leaving aside for the moment the existence of objections and appeals and so on, the Secretary of State is asked to decide whether or not a checklist has been filled in on the day, and we all agree that one should be filled in. On the evidence before the Secretary of State, she is reaching the conclusion that one ought to have been provided to me and wasn't, so there is no checklist. So for the Secretary of State, the Secretary of State's position prior to an appeal is that there is no checklist.
But if the effectiveness of the system comes from the fact of filling out the checklist, operating as it does on the mind, how can the failure to produce the checklist that you have carried out constitute a failure to implement the system under C?
My Lord, because it would be said that you haven't, the fact that you haven't produced it means you haven't done it.
Yeah, but once you get a finding that you have.
Right. My Lord, subject to coming back to you with confirmed
a better idea
or confirmed instructions, my position would be that if it is accepted by the court as a matter of fact that the checklist was filled out by the driver contemporaneously, the fact that he did not produce it at the time does not render the system ineffective.
Of course, that's not inconsistent with your submission that, so far as the Secretary of State is concerned,
yes,
that absent such a finding or such evidence, the Secretary of State would be entitled to say that failing to produce the checklist, the
Yes.
Secretary of State's entitled to conclude, well, there isn't one, and therefore there's a failure.
Yes. My lady, my lords, I've dealt with a number of other aspects of this judgment already, including the effectiveness of the system, the exercise of discretion, and I've already noted with the exercise of discretion here that Mr. Alcaz benefited from the exercise of discretion because he lacked culpability. I've made at the outset my submissions about criticisms of the adequacy of the codes and so on. So unless I was for a moment going to look back at those instructing me, but they aren't here, they're watching online. Unless
Could wave.
Unless the court has any further questions, those are my submissions.
Well, are you going to deal, you've just been dealing with Co there. I'm sorry, you've dealt, did you want to say anything else about the Godsmark judgment? I mean, we have substantially your submissions, both
Yes.
picked out from what you've said and also from your written material, but you may just want to reflect if there's anything else that you wanted specifically to add in relation to that judgment.
Not a submission, but just a query, if I might. One thing I wasn't sure about is whether Mr. Kaznicki is actually party to this appeal, simply because he is said to have disappeared by His Honour Judge Godsmark in October, and I wasn't sure. I thought I ought to raise that.
I think he may have missed his moment.
Okay.
Which is very unfortunate for his former employers.
I think the question would be, because there could be circumstances in which you could say that his employer has a contingent interest and would wish to be joined to the sort of, but you haven't actually brought an appeal on his behalf, have you?
I have, but only as to the level of penalty. But in any event, an appeal by his employer against the imposition of penalties per the statute is implicitly an appeal against the driver's penalty. I can take your lordship to the section if necessary, but that's what it says, for very obvious reasons.
My lady, I've covered what I wanted to say, that the main points in the Godsmark appeal in my general observations.
I've got one more for you.
Yes, my lord.
I understand the position to be that the Secretary of State's criticism in Godsmark was that they didn't go into the load at every stop. That's what I thought we were being told. If that's right, and if we were to reach the conclusion that the relevant sections of the Prevention Code do not either advise or guide or whatever, stop going inside at every stop, would you resist the appeal on B?
My lord, I would have to take instructions in case there are any other matters that would be raised, and I can perhaps do so and alert the court as to that. I don't, as I indicated, my understanding is, and I wasn't present at the appeal, was that the Secretary of State was concerned that the inside of the vehicle was not checked at the last stop before boarding the ship. It wasn't that it wasn't checked at every stop along the route. That's just on instructions. I don't know what was argued below. Because what we're concerned with is paragraph 1.2.5, which falls under paragraph 1.2, which itself deals with measures to be taken immediately prior to vehicle boarding the ship.
Well, again, all right, well, subject to what my lord, my lady may say, I think we need to have clarity about the basis upon which the case was put below, because it certainly requires a different judgment or different terms to deal with if it's didn't go in at every stop, or didn't go in at the last stop.
Yes, my lord, I can certainly seek clarity on that.
So, speaking entirely for myself, and again, for my lord and my lady, I don't think we need to have a response before we go out of this room.
No.
But we would need to have a response fairly sharply.
It does look, from paragraph 18 of the judgment, as if the Secretary of State's case relied on section 1.2, because that's the bit that the judge recites
Yes.
at that point, and he doesn't make any reference to other parts of the code. So that, as far as it goes, that's consistent with your understanding of the Secretary of State's concern. But it would be helpful, I agree with my lord, to know.
Yes, and I can certainly seek clarity. It's useful, my lord, that in that paragraph in 18, the judge gives what I say is the correct approach to this matter, which is, he says that the code of practice, which is promoted by the Secretary of State and which is recognised in the statute, and that gives indications as to what may or may not constitute an effective system. The word indications is really helpful there. And what I would say is this: if it is SCAT's case that the code is unclear or that the requirements are unclear in this regard, these were arguments open to it to make in front of His Honour Judge Godsmark and to advance and say that the code doesn't require what the Secretary of State is complaining. I don't think that you, Judge, should require it either. And make those points. I don't know whether those points were made. And again, that's something that perhaps both parties can submit brief instructions. In short, I don't know if the kinds of points that are being advanced before this court on this particular issue were advanced before His Honour Judge Godsmark and whether they were dealt with.
I've just reminded myself that we do have the skeleton arguments before the county court, which may provide it, which I freely admit I have not read, but they may provide the answer.
Yes, I will have a look.
But confirmation would be very much received.
Anything else?
No.
Jeremy? Thank you very much indeed. Yes, anything in reply?
I can be very brief, but can I perhaps beg this of the court first? My only concern about the court asking for further enlightenment on what took place below is this. Is the answer to be provided in written form, or are we to return tomorrow? Because I see my Lord Shakespeare said I would wish to say something about that, regardless of what the answer is. And if now is the time, then I would say it now.
No, we don't do it. No. Now.
Thank you.
Please.
Whether or not a check is required or was seen by the learned judge as to been having required at every stop is to some extent not the real issue here. The real issue here is whether the check inside of the load area of the vehicle was required at the last stop before boarding the ship or ferry, because that's what the thing says. Measures to be taken immediately prior to the vehicle boarding the ship, aircraft or train to the United Kingdom or before arrival at the UK Immigration Control at Coquel. And then we get into one of those ambiguities I've complained of ad nauseum per this code of practice, because 1.2.2 requires, where used, check that seals, locks and other security devices have not been removed, damaged or replaced. If you're going to remove them and thereby damage them in any event to check inside, why bother? Because they're gone. And 1.2.5, check inside the vehicle. Well, we there the difficulties with that proposition. And I would hope that we have come to the conclusion that 1.2.5 is not helpful in answering the question whether or not a check inside of the vehicle just before it enters the relevant area is required because of the language of 1.2.5. The second part of the paragraph is plainly directed at those vehicles which do not benefit from other security devices, such as a lock or a seal, etc. Whereas the first part of the paragraph refers to alternative checks that may be taken instead of removing seals and opening the thing up and looking inside. And so checks at every stop may be a little bit of a red herring, and I would rely on the proposition that goes, you don't need to check inside the vehicle at every stop regardless. But what is a haulier to do when confronted with this advice when he arrives, as my learned friend would have it, and I disagree, 20 miles from the port and does his final check there? That's what I would say about that.
Thank you.
But forgive me, that leads me on to the next point I would wish to respond to, and it is that aspect of my learned friend's submission which goes, actually, you can conduct your final check pretty much where you want, up to say 20 kilometres, I think he used the example of a petrol station, before getting to Calais, so long as it is conducted. I'm afraid that's inconsistent with what this court said, and I believe it was part of the Constitution, in ICS, the ICS car case, which appears in the bundle, and I would beg to take you to the case in the authorities bundle, and the position appears behind tab 13 of page 212. And if I can take you to page 220 of that decision, where they consider this very point. And paragraph 42. The large part of paragraph 42 talks about the journey itself. But then the last sentence, which begins second line up from the bottom, however, whatever the reason, the evidence is clear that the last check of the vehicle took place over 100 kilometres from Calais. Over the page, Mr. Siney submitted that it was immaterial where the last check was carried out, provided it satisfied the section 34.3b test of being part of an effective system for preventing the carriage of clandestine entrants. And it seems to me that the letter friend's submission is just that you can conduct that last check well before arrival at Calais, so long as it is the final check required by the Code of Practice. Lord Justice Simon said this in dealing with that. It seems to me that there are a number of problems with this submission, paragraph 44. First, although paragraph 1.2 of the 1999 Code could have been better expressed, the intent is clearly that the checks described at paragraph 1.2.3, including inspection of the roof, should be carried out immediately prior to the vehicle boarding the ship or train, or, where applicable, immediately before arrival at UK immigration control. That's a reference to Cockale. Secondly, the printed form of the owner's vehicle security checklist envisages a final check, which is plainly not carried out. 45, in my view, the appellant's contention that a system which involved a last check which was carried out over 100 kilometres from UK immigration control constitutes an effective system for preventing the carriage of clandestine entrants is unsustainable. That must be right in my submission, and my own friend, I respectfully suggest, is bound by that conclusion. Not simply because that is what was said in that decision, but because we go back to the propositions of the opening of vehicles in areas such as parking, petrol stations, etc., where goodness knows clandestine entrants, and more importantly the gangs who deal with them, know exactly where the trucks stop en route all the way down to Calais or Cockale or Dunkirk.
But in Godsmark, which I think is what you're addressing at the moment, I understand exactly why you've taken us to this.
Yes.
But it doesn't really matter whether you did your final check on the ramp or 20 kilometres before, because whenever you did your test, your check, you didn't go into the load.
Yes and no, because I argue, as my Lord knows, that I say it's not a requirement of the code to go into the load.
I know, but as a matter of fact, and as a matter of your system, in Godsmark you didn't go into the load when you had a sealed lorry
No.
or a sealed vehicle that you didn't go into load on your final check whenever you took it out.
Yeah, and I submit for perfectly sensible reasons.
Well, that's as may be.
Yes, but one wonders what the truck does in the queue of 50-odd trucks waiting to get into the harbour, and whether or not one ought to conduct a check at the harbour gates with all of the issues we've contended with, and whether the language of the code immediately before boarding is to be complied with or not.
Well, it's to face that in the practicality issue that the Secretary of State has decided that a petrol station 20k away would be satisfactory, and immediately is a superfluous word.
Yes, but it's not what was decided
No,
by this.
Understood.
One or two, if I may, minor points. But before I deal with those, can I answer my Lord's question about bundle and page numbers, which you asked earlier? You asked about page 45. That can be found at page 41 of supplementary bundle 2, volume 2, in the Link and Cosicha case.
Sorry, let me just find the right place to write that.
Page
41 in the bundle.
41 in the bundle.
The reference 45
Yep.
it equates to 41 in the bundle. And that's the Link and Cosicha bundle, volume 2. And the reference to page 48 can be found at page 44 of the same bundle, Link and Cosicha, page 44. And immediately before 44 is 43, a translation of that document.
Thank you. Yes, now you said you had another couple of points.
Just very briefly, you heard quite a lot about the Secretary of State's decision making and what she is or is not to do. But in my respectful submission, that's all well and good. And I race through this. But that is not the issue in contention here. The issue in contention here is, regardless of what the Secretary of State may or may not have thought about whether or not there was an effective system in use, what the learned judge thought that mattered, and that's what we're dealing with today. And the point has already been made by my Lord that in at least one instance, the learned judge effectively overruled a finding of the Secretary of State and found in favour of one of the appellants. The adequacy of reasons, and this is my fault because I didn't make myself clear, does not go to the adequacy of the Secretary of State reasoning. It goes to the, well, my lady has it, it's all about how the level of penalty is fixed. And that's where the complaint lay. I wonder, and I ask very politely, please, and respectfully, am I required to respond to the argument that goes, I have no basis in this court to argue that the prevention code is inadequate and poorly drafted? But in reality, that is a public law argument that ought to be advanced elsewhere.
Just a moment. Yes, fortunately, we're all agreed about that.
Forgive me, I'm so sorry.
Is that you're entitled, we say, to argue that it's poorly drafted and to give us examples about why it is, and therefore it shouldn't be interpreted against your client. What you can't do is launch a wholesale, what would inevitably be a public law argument against.
Which I tried very hard not
and
to.
I'm conscious of that, but I think that.
So my application is not to invite you to reconstitute yourselves.
No. So we will approach your arguments on that basis.
I'm most grateful. Thank you. Another friend suggested that I conceded that a company is liable for their recalcitrant driver. Sorry, did my lady hear?
No, I was just listening. You dropped your voice.
Yeah, it's been a long day. I don't, for the reasons that we have dealt with. We discussed at a very early stage the black letter law on the subject, and that if the system was not being properly implemented on the day in question, I argued or sought to argue that you should not lay that by the driver. You should not lay that at the shoes of the company, and resolved to a degree from that argument in the face of the black letter legislation. But then I went back to the argument, particularly given the Secretary of State's view, as expressed in her publications, of the position that actually it is something you can take into account. I say no more than that because I really don't want to rehearse the arguments again. But I'm by no means certain I made the concession that is suggested. Similarly, the argument that goes that the driver and the haulier stand and fall together, I've made the point that they don't, and His Honour Judge Godsmark is, I would submit, sufficient evidence of that position when he decides in the Ocart's case that the driver could be separated from the haulier. And the final point is this, if I may, and it's the reference or the allusion to the proposition which goes, I'm barred from raising the issue of the accreditation code because it's not something that was pleaded in the grounds of appeal. I respectfully disagree with that proposition. The grounds of appeal, certainly in the SCAT transport case, ground 1 complains that only Judge erred in law, forgive me, page 57 of the core bundle of the SCAT.
Thank you.
I shan't read it out. It is a general complaint that the judge erred in law in making his findings as he did. I would respectfully submit that when I make that general complaint, I am allowed to point to those aspects of his findings which I seek to complain about and deal with them before this court. And in dealing with the accreditation scheme, which frankly I confess I had not considered an important point at the outset, but it became important when my Lord mentioned it in dealing with the Godsmark appeals. I submit I am in that way entitled both under that general ground of appeal to deal with it and to respond to my Lord's query about it. And so I'm not barred from raising or relying on it, I will submit. If I'm required to apply for permission to amend my grounds of appeal to include that, then, my lady, I do so.
Thank you.
That is pretty much all I have to say. You'll be relieved to hear.
Well, thank you very much indeed.
Can I ask one question then, please? We're not back tomorrow.
No.
If, and it's a very big if there is any success on my part, I would ask for the consequential orders, please.
Yes. Well, what we will do is, you won't be surprised to hear that we're going to reserve our judgments in this matter, and we can't say precisely when they'll be handed down, but as soon as is practicable. They'll be sent out to you in the normal way as drafts for typographical, grammatical errors and minor factual errors only, not as an opportunity to relitigate. And then we'd hope that any other matters can be dealt with on paper, including issues of costs, and then hope you could agree an order. And if I can thank you all very much indeed, and if I can particularly thank your junior, who obviously has had a complete grip of the case and has been able to, I think, assist both sides and certainly the court with her familiarity with the papers.
Thank you, most great.
Anything else? Yes, Ms.
My lady, may I just ask how best to communicate our...
Through my clerk, and you'll be given details.
I'm grateful.
Not at all. Anything else that arises
No,
now?
thank you.
No. Well, in that case, thank you both, all three of you, and the people behind you and who've assisted you, and all the people on live stream who eventually, we hope, will be able to be back in court in the normal way. Thank you all very much.